Welcome, everyone, and thank you again for attending. We appreciate you joining us for this third of our COVID-19 webinar, this one on reopening. I want to speak to you first about a couple of housekeeping items. First, we, again, don't want this to be a lecture. We hope that you will ask questions. To ask questions, please feel free to join us in the chat. We'll be taking questions during the event and at the end of the event. Second, I just wanted to mention that the event, again, will be divided into several sections. Each section will be about 10 to 15 minutes. We have 4 sections, and we're hoping that we'll be able to cover all the material and be able to answer, again, any questions that you have. Third, although we take ourselves seriously sometimes, we don't want to take ourselves too seriously today, and we want this really to be something that you enjoy, that you participate in, and that you ask the kind of questions, whether we covered them or not, that you want to hear from us today. We're hoping this will be light, enjoyable, and to that end, we encourage you to participate, be part of the Q&A. I also wanted to mention one other item as we move forward. This is usually the time of year, actually about a month or so ago, that we would have seen the cherry blossom run, and we typically have participated as a firm in this event and have always been very charitable with our time and our money. And because the event was canceled this year, we wanted to let folks know that at the end of this event, it's our plan as a firm, Milt and I, to make a donation to the Children's Miracle Network Hospitals, which is what the run sponsors. And we hope that with that, you'll stay with us till the end. You'll ask us some questions, and hopefully with all the questions answered, we'll be able to move forward. And we really appreciate your joining us. We really appreciate your participating with us today. And let's go forward. Let me begin with introductions. I'm joined today by my partner, Milt Theologu. How you doing, Milt?
Great. How are you, Gary?
Good, good, thanks. I think I threw that charity thing in before I spoke to you, but I know you're good. All right, thanks, Milt. Hey, I'm also joined by Ron Cantor today. Ron, thanks for joining us today.
Thank you. Thank you for inviting me.
Seth Behrensweig from the law firm of Behrensweig Leonard. Thanks for joining us as well.
My pleasure.
And then we have Chris Staub and Jonathan Silverman for joining us today. John will be taking questions. John, you can hold up the question device if you'd like. There it is, the question device. Again, we'll be taking those questions during the event, and we'll be taking those questions at the end of the event. So let's get started, and let's move to the slides. Rob, if you could put up slide 2, please. So as you can see, as governments begin to lift stay-at-home orders and credit unions begin to reopen in accordance with state and county sanctioned phased reopening, what's this all going to look like? How's it going to look to us? How's it going to look to credit unions and their members? So I thought I'd start by doing something that you'll probably be doing yourselves quite soon, taking temperature. So we took a look at polls, and as you know, from the first 2 events, we looked at some polling data and tried to get a determination as to what was going on and what people saw. At that time, there was a prediction of unemployment at being at over 25%, that people were going to have to use the stimulus checks and other monies so that they could pay their bills and make sure that basically that they could live. And what we saw from that is, from recent polling and from recent data from the government is that we're not really seeing that information. We're not really seeing folks using the monies in those ways. So if you take a look at these 2 data points, what you'll see is approximately 25% of people are using the stimulus checks for necessities like rent and food. About 50% of it is going to pay bills. 25% of it is actually going to consumer products and electronics. I guess with the kids home, or if you're home, you may need those things. And then the unemployment that was expected at 25+% is hovering somewhere between 14 and 17%. More importantly, once you see a lot of the workers go back to work, restaurant workers and hotel workers, that unemployment will probably look something like 7%, certainly not the 25% that was expected through the end of 20 or maybe even 2021. So the government, credit unions, everyone is struggling to the right way to reopen, taking these data points into effect and trying to make a determination as to what people really want. Do they want to come into credit unions? They won't even go back to work. you'll see the last data point here that talks about 80% of Americans polled favor unemployment and stimulus checks continuing through 2020. That being the case, people will make a decision as to whether they want to go back to work or not if they're making more money on federal and state unemployment. So with that said, let's talk about what we're going to cover today. And you'll see the last 4 bullets here. We're going to talk about court phase reopening legislative action, CFPB action, best practices in HR. With that said, let me turn this over to my partner, who's going to talk to us about legal considerations reopening the courts. We've got a few charts here that are going to give you information on the reopening of the courts, on what you can and can't do when the courts reopen. I don't think Milt's going to read the information, but it's a good primer and something that you may want to take with you afterwards, and we'll tell you how to do that. Milt?
Thanks, Gary. As the courts are moving forward now into the reopening phase, what we're trying to do is give you all a snapshot or an understanding of where the courts are currently and where they're going to be in a couple months over the summer. So if we could go to slide 3, we see that Maryland has a phased-in approach. Phase 1 is March 16th through June 5th. So we're already past phase 1. We're currently into phase 2. Phase 2 and 3, the courts are considering remote hearings. We haven't really heard much on that other than the possibility of remote hearings. We know that, for example, Montgomery County, which is the county where our head office is located, has opted for a Skype platform. Other courts are moving towards a Zoom platform. The situation is very fluid right now, so we'll keep an eye on it and keep you updated. The bottom line is civil jury trials aren't going to start until phase 4 in Maryland. So you can expect not to be in court until late August, early September at the earliest. In DC, although the courts have reopened, there really aren't going to be any civil collection matters being heard in DC until about the end of July, early August. There is still that DC moratorium on collections, and that'll expire on August 10th. So you should expect trials to be canceled until then, and again, to pick up in early September. If we can go to the next slide. In Virginia, the Supreme Court allowed courts to reopen beginning May 18th. That was up to the discretion of the individual jurisdictions, counties in most cases. And courts are still struggling to adjust their calendars, and they're spreading out hearings and limiting the number of cases that can be heard in a day, and attempting to consolidate all matters from a firm to a specific date and time. Also, sheriffs have have resumed to serve process in most jurisdictions, but it's really up in the air. It's an ad hoc process. In California, much like Virginia, the decision-making is decentralized, and the authority to open the courts rests with local officials. In Washington, although non-emergency civil matters have been continued to the beginning of June, priority is given to emergency matters. So really what we're looking at are civil collection matters probably won't be considered until the latter part of the summer. They're going to be put on the back burner, and even when they are heard, they will be heard remotely. And that's really the catchphrase with all hearings this summer. There will be remote via Skype, via Zoom, or telephonically. If we can go to the next slide, please. Bankruptcy courts are open and conducting hearings telephonically. If consumers are allowed to file bankruptcy, there are no limitations to that, and bankruptcy courts are reacting and trying to stay open as much as possible. And to that end, those hearings will be conducted, again, remotely or telephonically. With regards to foreclosures, the specific jurisdictions where we practice are listed on your screen. I'm not going to go through each one of them, but most jurisdictions, with the exception of Virginia and North Carolina, have suspended foreclosures until midsummer. If we go to the next slide, please. Repossessions. There are no prohibitions against self-help repossession in most of the jurisdictions where we practice. The obvious exceptions are Maryland and DC, where the ability to begin to repossess collateral are tied with the health emergency declarations. And lastly, garnishments. With the exception of DC and Washington, all other jurisdictions are accepting and allowing garnishments. But even those jurisdictions that are accepting garnishments, it doesn't mean that they will be processed timely. The courts are dragging their feet or taking time in processing these garnishments. And so that's where we're left. The court is trying to return to normal, but it's not quite there yet. So hopefully that was a good overview of where we are in the jurisdictions where we practice. If you'd like a copy of the PowerPoint and what I went over, there will be a link in the description below on the YouTube link. So with that, I'll throw it back to Gary, and he can talk a little bit about the federal legislation.
Thanks, Milt. I appreciate it. I also want to let everyone know that you can also find today's event and the other two events on our firm's YouTube channel, LinkedIn page as well. You can find a PDF copy of this on our website for download. So if you want to print any of this information that Milt talked about today, you can. And it's also available for viewing on our website too. So there's a couple of places to see if you missed it today, or if you want some of the information to print out and hand out to other folks in your office. We try to put a lot of information into these slides to use them as reference so that you can use them as reference materials after these events are over. So now that we've provided an overview of where the courts are, I want to once again talk about where we are in legal action, on legislation. And I guess that leads us to the HEROES Act. Thanks. I didn't even have to ask Rob to move the slide. He did. So let's talk a little bit about what's going on with the HEROES Act and where we see that going. So back about a few weeks ago, mid-May, the House passed legislation, 1,800 pages worth of legislation. And you'll see in the slide, I call it a Democratic proposal. And the reason why is because this was purely voted along party lines. HEROES is the acronym for Health Economic Recovery Omnibus Emergency Solution Act. I guess HEROES is easier to say. What this does, if you look at the highlights, you'll see very specifically, the bill extends emergency family leave and medical leave to 2021. It adds another round of stimulus payments up to $6,000. It extends the $600 a week federal payment for unemployment in addition to state unemployment. So if you're at the highest level in Maryland, example, potentially your payment could be as much as $1,000 a month. So it's a big number, and it extends to the end of the year, and it'll go to something I'll talk about in a minute. There'll be additional hazard pay. There'll be $1 trillion to state and local and tribal governments, $500 billion in direct and flexible aid to state governments, $200 billion in pandemic. It's how all of that gets up to $3 trillion, basically. You'll see the large bullet that I put here, which I think is most interesting to our credit union clients, which is if this legislation passes, buried in the 1,800 pages is about 10 pages from the House banking bill that discusses what will happen with debt collection in the event this actually becomes law. And what you'll see is that basically all debt collection in America by original creditors and debt collectors will be suspended for the term of the federal emergency and 6 months. You can read in the bill, it actually says debt payments of all kind will be voluntary. Once you get past that, what you'll see is that original creditors are now deemed debt collectors. And because they are, everyone would be now part of would be subject to statutory violations under the FDCPA. But now this bill increases those violations by 10x. So where you try to collect your debt, your violation for trying to collect the debt would be $10,000 per, as opposed to the $1,000 per right now. The hard part about this is that the Senate had a bill recently that did not get out of committee that tried to address these very same issues, but mentioned the fact that were banks to apply for the loss to the government for not being able to collect their debt, the government would be able to compensate them, but that was directed to banks with shareholders. And I was going to say by a show of hands, how many people out there are banks with shareholders? I don't see any hands, so I'm assuming it's none of you. So this would not be something credit unions could take advantage of. They would just have to absorb their losses. The other side of this coin is Senate Republicans and House Republicans have said that they'll move to oppose this bill. The president said that he would veto it in its current form. So I don't know that this particular bill is going anywhere, but here's what I can tell you. There will be another stimulus bill. Something will be passed. There's all sorts of conversations right now about additional monies, about what those additional monies will look like. And we'll need to continue the conversation to see what this is going to look like. And we'll keep you posted on it as that goes. Rob, let's go to the next slide, please. So let's talk about some of the observations and best practices. So what I talked about was, my slides just started moving without me. Pardon me, folks. Thanks. So if you take a look at these bullets, and I put them up front and I said I talk about it again, the intended purpose of the monies for stimulus, which was to keep people going during this time, is not something we're seeing most people doing. What we've seen as a collection firm, as an example, is people coming to use those stimulus monies to pay down debt. And again, the polls sort of show that's where this is going. The 25% unemployment is much lower. Businesses are opening sooner than they thought. And so looking at that, what I think credit unions need to do is start thinking about, it's time to reopen. How do their members want to address them? If they want to pay down debt, how are they doing it? Some of our clients have said to us, well, we're just giving anyone who calls us, it doesn't matter what they say, we're just putting them on an extension. That's not a problem, but there are people who want to use some of this money to pay down debt. And my suggestion would be, when that opportunity presents itself, you should take that opportunity. That said as well, people want to come into the branches. People want to do business. How are you going to let them into the branches? How are you going to do business with them? How will you exchange money or not? And I think the other thing you need to think about is how you're going to deal with your members and your employees as they're in the branch. The other folks will talk about that a little bit more. My time is up, but I just wanted to mention two things. First, the day of reckoning, and I just stole something that Ron was going to talk about, but mine's different. The day of reckoning is coming on how we're going to deal with collections for firms that, like ours, who haven't seen a lot of work, for some who haven't seen any work. These collections are piling up, and you have to make a determination as to how you're going to deal with them. Are you going to batch them out? Thousands of cases going out in a day, and what the optics of that will look like, or are you going to spread it out? Do you have a plan to deal with that? If you don't, it's time to start talking about that plan, because July, August is when people have the expectation you'll see that roll out. And then how you're going to deal with your members in this situation may be a little bit different how you thought you were going to deal with them, only because, again, more money is coming. They have the money they have. And how do they want to spend that money? You may think it's one way, but I think it's time to start thinking about some other plan as to how you want to speak with them about how they want to use those stimulus funds, pay down debt, and work with you. Our position has always been, it's kinder, gentler, and you deal with folks on their level. Don't give them something they may not want, but certainly listen and see what they want. So those are my practical tips of advice. You'll see some helpful hints at the bottom of this that talks about reopening. There's a hint on 50 states reopening. There's some hints from the U.S. Chamber of Commerce on reopening and reopening manuals. That's all I have. I'm going to turn it over to Mr. Cantor.
Thank you. Thank you very much, Gary, and thank you for your
Thank you, Ron.
Milt's very informative coverage of this burgeoning reopening. If we're at the next slide now, I've been asked to talk about the upcoming regulatory environment. And I'm going to start by talking about the Consumer Financial Protection Bureau, which the credit and collection industry has had to deal with now for almost 10 years. And their 10-year anniversary is coming in July. Gary had asked for a show of hands earlier about anyone having shareholders. I'm not going to ask for any applause for this, because I don't think anyone in the credit collection industry is celebrating the 10-year anniversary of the Consumer Financial Protection Bureau. There is, however, potentially a earth-changing event that may happen as to this Consumer Financial Protection Bureau's existence or how they have been conducting their regulatory practice. The Supreme Court is due to decide, probably by the end of the month, the case of Celia Law versus Consumer Financial Protection Bureau. The Supreme Court agreed to take this case and to decide two questions: whether the Dodd-Frank Act that established the Consumer Financial Protection Bureau violates the Article 2 of the Constitution by vesting in a single director broad authority where that single director can only be removed for cause. The question was, does that interfere with the Article 2 delegation to the president of the exclusive sole authority to see that laws are faithfully executed? Surprisingly, the Bureau agrees that it is unconstitutionally structured because a removal for cause violates Article 2. And the Bureau said so before the Supreme Court. However, what the Bureau suggested to the Supreme Court is you simply excise, take out that offensive provision, and let the Bureau continue to operate as is, with the understanding that the president, whoever that president is, can remove the director at the president's discretion, similar to how the president can remove cabinet officers from their positions. So a possible outcome, and I think this is probably more probable than not, is that the Supreme Court may agree with the Bureau and simply excise out that for-cause removal and say to the Bureau that, or say to the president, you can remove the director on your own accord for whatever reason you want to. And this possible outcome illustrates the adage, be careful what you ask for. Because if in fact I don't want to say the enemies, the opponents of the Consumer Financial Protection Bureau, who have just cause to complain, certainly as to the prior director Caudre's policy to push the envelope and to pursue regulation by enforcement, the possible outcome is the president can remove the director, which means that if there is a new administration, a new director could be appointed without any congressional oversight. So there will be clearly a defining event that'll likely take place by the end of the month in terms of the Consumer Financial Protection Bureau's continuing in existence. Another potential outcome is the court may say, well, we're going to strike this down and you've got to start over again. Nothing that you've done prior to this was legal. You're going to have to throw everything out the window and then let the president appoint whoever he wants, and that new person can then exercise the Bureau's authority. So if we could go to the next slide, please. Let's talk about what the CFPB has been doing. And the CFPB has broad authority over both financial services businesses, which include direct creditors, such as credit unions, and law firms and agencies that the creditors hire to collect the bills. One of the elements of Dodd-Frank that was missing from the prior legislation was the ability to promulgate rules, to write rules interpreting the Fair Debt Collection Practices Act. The Bureau started to do that in 2013. They promised a final rule last month. They have not rolled that out, perhaps because of the pandemic. There had been some discussion that their rules would also regulate the conduct of original creditors. I'll focus back on what Gary had mentioned about the House passed a bill that would make original creditors subject to the Fair Debt Collection Practices Act. But the rules that they've written at this point do not really take into account the conduct of original creditors. All that being said, if in fact rules are finally written, Congress has the power within 12 months to simply abolish the rules, to undo whatever rules were written by the Consumer Financial Protection Bureau. This is exactly what happened in 2017 when, after Mr. Caudre pushed through rules that basically would limit to a great extent a creditor's ability to compel arbitration of consumer disputes, Congress went ahead and gutted that whole rule. The CFPB, if it survives, is going to be in your future. The CFPB previously has shown a willingness to go after original creditors and to push them with consent orders to basically do things that are not really specific in the law, but as Mr. Caudre had said, regulation by enforcement. We could see regulation by enforcement rear its head if there is a new president elected in 2021. So if we can move on to the next slide, let's talk about the regulatory environment post-closing. The CFPB came out with a notice probably in late March or early April that gave furnishers of credit information a little bit of breathing room. Say, we understand you're closed down. You may have time delays in responding to credit bureau disputes. We'll take that into consideration. And if you've responded reasonably, we're not going to hold your feet to the fire as to any 30-day requirement. Well, lo and behold, many state attorney generals didn't think that was a good idea and sent a letter out to the major credit reporting agencies say, we are intending on vigorous enforcement of all parts of the Fair Credit Reporting Act. So this is going to be an issue, I think, that you're going to see more frequently as time goes on. First of all, one of the provisions of the CARE Act addresses reporting of accounts where there have been payment accommodations. If they're not properly reflected in credit reporting, creditors can expect scrutiny and potentially private lawsuits. Now we talk about the day of reckoning. Gary talked about one aspect of it, but here's where I see it potentially coming into effect. There have been many states that have banned cutoff of utility services during the pandemic. There have been other states that have barred or extremely limited collection activities and judgment enforcement or filing new suits. Also, consumers have taken advantage of very favorable credit extensions from, for example, car dealers. I'm sorry, this should be on the next slide if we didn't advance. Car dealers. So all this is now coming due. Your utilities are going to be cut off if you don't pay up to date. There's now continued collection activity, and all of a sudden, the 3 or 6 month voluntary, no payments for 3 or 6 months are coming due. The question becomes, workers in hard-hit industries may not be returning to work. Will this be a day of reckoning for them? Will creditors see a significant uptick in delinquent accounts or failure to pay because of these circumstances? Last slide, please, for me. Finally, we're going to talk about state proposals. There have been movement in states, particularly I saw Colorado a couple days ago, to extend a bar on post-judgment garnishments. Colorado was going to do it for 10 months. My view is some of the restrictions are going to remain post-emergency, and there's going to be, particularly in the more aggressive states, a move to expand them perhaps 12, 18 months. You can expect, once the emergency restrictions are lifted, expanded scrutiny of repossessions, collection methods, collection litigation, and I think particularly discriminatory conduct in credit granting and in credit collection. As I said earlier, the state attorney generals are likely to lead the way on credit reporting investigations and enforcement actions. Please take as this final comment for me the fact that in several states, original creditors are subject to debt collection lawsuits for harassing or abusive conduct, including Maryland, Florida, and Pennsylvania. Many of those states require what are called ascertainable loss, in contrast to the FDCPA, which allows for statutory damages. But I think as we get out of the closing, as we move now to more reopening, I expect enhanced regulatory and enforcement action, both in private civil suits and by state attorney generals. And now I'm going to turn it over to Jonathan Silverman for just a few moments.
Thank you so much, Ron, and really informative stuff. Thank you so much. So just a reminder, we have our live comment section open. I'm monitoring it right now, and I actually do have a question for Milt, Mr. Theologu. When do you foresee civil collections reopening in DC, and how do you foresee the opening process of those cases proceeding?
Well, right now, the DC Emergency Act was extended to June 8th by the mayor, which means collection activity is halted for 60 days since, from June 8th. So we're looking at a start date right now of August 10th. when we can begin to file new lawsuits and have new filings. But that is a moving target. So right now the date is August 10th, but there's a possibility that that could be extended, especially if there's a second wave of cases and infections going on.
All right, thank you. And then one final question is, you state some collection restrictions will remain post-emergency. Which collection restrictions are likely to stay, and will these be permanent?
Well, that's exactly what Ron was talking about. Certain jurisdictions and certain states have garnishment protections or prohibitions in place now, and I believe, depending on the state, those might stay in effect afterwards. But Ron could probably speak to that a little bit better.
Right.
Well, I think it's an emerging issue. Stay tuned, because there likely will be bills again in the more progressive and liberal states to expand limitations on garnishments and other forms of creditor remedies.
Perfect. Thank you, Ron. And then final question before we move on, this would also be for Ron, is can we anticipate changes to the FDCPA in the future?
As long as Congress is split, I don't think that's going to happen. But you never know. If Congress turns out to be Democratic in 2021 as Democratic president, the answer, I think, is unequivocally yes.
Okay. Well, thank you all so much for answering those. And without further ado, we're going to move on to Chris Staub, who is a partner over at the Capital Group, and we'll be speaking about insurance as well as 401ks. So Chris, take it away.
Thanks, Jonathan. And appreciate everybody inviting me on the call. It's my first time on this call, and wanted to discuss two different items here today. One is unbelievably exciting. It's insurance and how you protect yourselves, your employees, and your office. And the second is actually very exciting to me, and that's the investment side and how can we take advantage of the current markets as we are dealing with this current market volatility. And if anybody's watching today, the market is down big because of potential reopening additional coronavirus cases coming out. So we can go to the next slide. We're going to start into a discussion on workman's compensation and general liability. And I'm not going to read through every bullet here, but workman's compensation is insurance that protects your employees from occupational hazards. And insurance is built in such a way to protect them from a normal slip and fall accident. They're doing something in your credit union, a filing cabinet falls on them, they slip in the lobby, and that protects them. But the question has arisen where what happens if your employees are exposed to somebody coming into the credit union with the virus and were to get the virus in that situation? Would workman's comp cover that in the current situation? And I think not to pose a joke here, but the jury's still out with all these attorneys on the phone. It depends upon your coverage and how it's structured, because workman's comp typically excludes ordinary diseases of life. But if your employees are actively engaged with people that could have that disease, then there could be workman's comp coverage. However, if you are a nurse or a doctor and you're on the front lines, without a doubt, that's going to be a coverage. But if you are an employee in a credit union working with customers that are walking in, the question is, would that coverage exist? And I think that's something that you need to examine with your insurance agent and your policy to see how that structure is there. And then you start flipping to the general liability question of how do you protect yourselves as a business from your customers walking in and them getting exposed to the virus. And I think the big thing is in this scenario is documenting what you're doing inside of your business to protect both your employees and your customers walking in. And you want to make sure that that is documented and memorialized as best as you can, because in the end, when it comes to insurance and it comes to liability, you want to make sure that you can defend yourself in the court of law, and having documentation about your policies and procedures and everything that you're doing, I think is key. So insurance is there for the right reason. There are certain clauses that are in insurance policies that tend to make it difficult sometimes to get coverage, but in this scenario, there are a lot of insurance companies out there that have policies that are maybe a little bit more stringent than others. And there is actually a class action lawsuit going on right now that is talking about whether or not insurance policies should cover COVID-related instances for both your employees and for your folks, customers coming into the building. So we're going to talk real quickly about in the next slide about really protecting yourselves, protecting your employees, protecting your customers coming in, and what can you do. And this is a lot of very simple things, but I think it's important to note that you want to, again, take every precaution necessary in your place of business. So everything from employers mandating that employees use PPE, personal protective equipment, and these could be things like shields, face masks, hand sanitizer, plexiglass in front of your customers, which I know a lot of you already have. You want to make sure that you're offering it, and you want to make sure that when a hazard exists, as it does now, that you know that employees can actually demand that you are supplying this information and these items to them. So gloves, goggles, face shields, respiratory protection. We talked about temperature checks and making sure that you're regulated in the in the building there. So you want to make sure that you are considering alternative options as well. Everything from training, use and care, and cleaning of that protective equipment is very much key for your employees, and making sure that your plan is periodically reviewed and documented, because as you've seen from the last couple of calls, things are changing every day with coronavirus and the response and the reopening. So you want to make sure that you are always updating your policy procedures, and even if it's keeping the policies as is, you want to document that you reviewed it and that you've kept it as is, and that's very, very important. So let's go on to the next slide and just look at a little bit of, I think, very simple, helpful hints to reopening. And I know we've done some of this here at the Capital Group. We have a little over 50 employees, and we've started actually implementing work schedules and making sure that people are utilizing face masks and such while they're here at the office. But you want to limit member and staff occupancy. Obviously, it's a little bit more difficult than probably in my business to have employees working from home if you're in the credit union space, especially if they are customer-facing employees. But limiting members and staff occupancy to the building is very important. You want to make sure that you're creating one-way aisles. You want to make sure that you have things on the floor to talk about social distancing and 6 feet apart. You want to make sure that the floor plan is adequate. So if you have what everybody has been moving towards, which is the open office environment, and now we're going to more closed office environments to try to protect each other. If you have to put up plexiglasses in between desks, it's advisable to do so. You want to make sure that you are using all the precautions necessary to protect yourselves and your employees as they are coming back to work. Now, I want to move on to just something that's a little bit different and we did discuss this before, but I want to talk about the current market volatility and something that's a little bit different that we feel like credit unions can take advantage of right now. If we can go to the next slide. Not sure if a lot of folks know it out there, but a little over 10 years ago, the NCUA has implemented some rule changes that does allow you as a credit union to actually take part of your permissible investment portfolio and invest it in impermissible or non-traditional assets for the sole purpose of paying for employee benefits. So we just talked about insurance to protect your business and your employees, but here we're talking about insurance and other benefits that will allow you to enhance the offering to your employees from a benefit standpoint. Those costs are going up and up and up every year, and we have the unfortunate job of delivering a lot of sometimes bad news with insurance carriers increasing health insurance premiums and ancillary premiums to our clients. And we've discovered a way where we can actually help credit unions leverage their portfolio and take their permissible assets and invest up to a certain percentage into an impermissible portfolio in stocks, bonds, real estate, things of that nature. And you can use it to pay for things like employee health care, 401k plans, long-term and short-term disability, long-term care policies, all sorts of different benefits. And you can also enhance your benefits as well. And we've been working with credit unions for the last 18 months or so in the DC area with this very concept and have had a lot of success. And although the last couple of months have been very volatile, there's also been a lot of really good opportunity with the market. And we've had a lot of positive experiences with our clients in working with them on their pre-funded benefit accounts. And that's what we're talking about is pre-funded benefit accounts. You're able to have a higher yield. And you can go to the next slide and really increase your ROA. We feel like currently, and we've seen that in the last 18 months, that with interest rates on your permissible portfolios declining at a rapid rate, and with the Fed continually yesterday, I think it was saying that they're going to keep rates as is for the foreseeable future, well into 2021, your loan rates and your overnight lending rates are drastically decreasing. So the question is, how can we continue to increase revenue or stabilize revenue so that you can continue to offer benefits and continue to operate? And pre-funded benefit accounts are a way where you can take part of your permissible portfolio, put it into impermissible assets. We have a goal of achieving about 200 to 300 basis points above your permissible yields. And as we've seen yields drop from about 2.5 down to below 2 for most of our credit union clients, we're able to get in that 5 to 6% range on an average basis over a market cycle, and really help to enhance the bottom line of a credit union's portfolio. And we can do this with controlled risk. And I think that's the big thing is we're not going and just buying options or covered calls or doing a bunch of risky stuff. We are managing an asset allocation policy. We're creating an investment management statement for our credit union clients, making sure that we are achieving that goal on a good risk-adjusted basis. So benefits pre-funding allow credit unions to we always say try to offset the cost of benefits, but it's very difficult to do that. But try to offset as much as we possibly can of their benefits cost. And this volatile market right now, although some people think of it as a risk environment, we think of it as an opportunistic environment. We think that it's a very good time where we can work with our clients to enhance their returns and enhance their underlying income on a quarter-by-quarter basis. So I'll stop there, and I'm going to go ahead and turn it over to Seth Berenswag from Berenswag Leonard, who's going to actually talk in more detail regarding human resources and protection of your employees and how to deal with some of the new laws and statutes out there. So, Seth?
Hi, good afternoon, everybody. My name is Seth Berenswag. I'm the founding and managing partner of Berenswag Leonard. We're a business law firm here in the DC metro area. And I'm here today to talk about the kinds of issues that we see companies dealing with and our clients dealing with every day. We're going to jump right in to the issues related to how to handle human resource and employment issues during this summer of COVID. Now, of course, we are engaged in a historic moment from a business perspective, and credit unions are, of course, as businesses, employers. And we are facing, as employers, a unique historic moment in terms of how to handle a variety of HR management issues, because Congress has recognized that we have an emergency and therefore implemented a variety of emergency relief acts. And the first slide that I'll be covering today touches upon one important aspect of that with regard to paid sick leave and family medical leave. Congress recognized that because of the COVID crisis and the obligations of needing to telecommute, that there needed to be new and additional rules that were layered on top of the current existing regimes in order to ensure that people have the correct amount of coverage. So quite simply, they apply as I apply it, the rule of 2 and 10, specifically that now individuals on your staff have an additional of up to 2 weeks of paid leave at their regular rate of pay, and an additional of up to 10 weeks of expanded family and medical leave as it relates to not only taking care of themselves and a loved one, but this has also been expanded with respect to taking care of children. During the school year, it related to the fact that the kids are home from school. During the summer, the regulations have been enacted to clarify that that also applies to an absence of summer camp. So therefore, at least as we're going through the summer, these specific leave provisions are going to be in effect, and Congress has recognized as a matter of part of the emergency legislation that we just need some new rules of the game here. And hopefully the shift from this will move ahead to reopening as we plot our way through the crisis. And as we'll talk about in a moment, we'll be focusing on that aspect as well. Now, going over to the next slide, if we may. One of the aspects of human resource developments that have occurred during this crisis, which has also been of a historic dimension, relates to the so-called Paycheck Protection Program, the PPP funds. Congress recognized that small businesses, including those up to 500 employees, are going to need an emergency injection of capital in order to make sure that they're able to continue operations. Round one was a slight debacle and really was done within a matter of days. We're in the middle of current round two of the PPP funds. There's still several $billions left. It's supposed to apply for the next several months. This round is going much more smoothly, but let me just walk you through basically what's going on. A couple of days ago, the president signed a new bill that provided some relaxation and some additional flexibility relative to how to be able to use PPP funds. Whereas when businesses got PPP funds and they had only up to 8 weeks to be able to apply those funds, there's new laws and legislation in place now whereby the company can use those PPP funds and spread them out for the rest of the year. Furthermore, instead of having a strict 75-25% rule whereby 75% went to cover your HR payroll and 25% went to your rent and other allowable expenses, Congress decided, you know what, let's just loosen that up a little bit and give more flexibility. So now it's a 60-40 sliding scale where you can provide up to 60% of PPP over that longer period for your payroll and up to 40% for the other permitted expenses, primarily rent. And the good news is that if you use these funds, which is initially provided by way of a promissory note for a loan, and you allocate them in the permitted way, then the law is such that the loan is converted into a grant, and then you do not have to pay that money back. So there's been a lot of questions that have come in terms of the application of that. The new law by the president that was signed, of course, is an important element. One of the other pieces that's been a brand new critical aspect under the terms of business survival for employers such as credit unions is the aspect of an emergency extended furlough. Under the new provisions, laws have been dramatically changed to really beef up state-based unemployment coverage and insurance for people who lose their job temporarily. And what has occurred is that Congress had, in the Emergency Relief Acts, has provided a new safety valve whereby, in order to preserve capital, you as the company are permitted to temporarily furlough employees. Those people can go off of your payroll so that you can have a preservation of capital. They go onto their state-based unemployment benefits, and then there's a new turbocharged state unemployment benefit, which is supplemented by an additional $600 a week. Bottom line, you can not only use your PPP funds for capital preservation, you can take currently non-essential personnel as you wish. You could put them on temporary furlough. They get virtually 100% coverage of their benefits. And then if and when you're ready to bring them back, then you can bring them back into the company and then put them back on payroll. These are historic changes that have been provided by Congress. This really provides a lot of emergency flexibility, especially as it relates to the emergency furlough. So suffice it to say that the Congress has stepped in and provided different layers of emergency legislation in order to provide you different avenues to be able to make sure that you continue to stay in business, because As Congress is aware, small business is the main engine that drives the American economy, and Congress wants you to take advantage of these additional and unique historic benefits. If we may, let's move on to the next slide. This is going to cover some other changes. What we've basically been doing is talking about some of the major historic changes that have been implemented as a matter of federal law that are crucial for you to be able to take advantage of certain historic opportunity to be able to preserve capital, manage human resources, and things of that nature. But it's important for you to also be aware that there have been some historic developments that have dramatically changed the texture of law on a state level. In Virginia, Virginia used to be known as kind of the Wild West as far as employment is concerned, because employees had very, very few, if any, rights. There was really virtually no state-based discrimination claims. Everybody just went through the federal cycle and went to federal court. Effective July 1, there's going to be an immediate and dramatic change in Virginia, where there's a whole host of new legislation under the Virginia Human Rights Act, which as a bottom line suddenly turns on a new valve of brand new claims that never before existed in Virginia, whereby people can now go directly under state law to Virginia state circuit courts and prosecute new claims against their employers for a whole variety of discrimination claims that never existed before in the Commonwealth of Virginia. Also significantly, there's a new law in Virginia that is very, very exacting and punishing on an area that was never before really regulated that much at all, as it relates to misclassification of employees. People who have employees either directly or remotely in Virginia used to misclassify and really be very sloppy as to whether someone who was a W-2 employee just got slapped with a 1099 independent contractor label. Well, effective July 1, all of a sudden there's a new law in Virginia that says that if you do that and get caught, you're going to get hit with a cause of action. You're going to get penalties, fines. There's going to be a right to recover statutory attorney's fees. This is going to be a really big deal. And to make a long story short, Virginia is suddenly the new California, because you have these all new HR related employment issues that are popping up in Virginia that you really need to be aware of. I'd also like to just finish this slide by pointing out that Maryland didn't want to be left out of the act, so they have a couple of changes also. I think the biggest change in Maryland, especially as it relates to the current moment of crisis we're in, relates to the so-called Maryland Mini Warren Act. It's part of the Maryland Economic Stabilization Act, which now says and requires employers with at least 50 employees that operate industrial, commercial, or business enterprises in Maryland to give at least 60 days written notice of any implementation of any reduction in force. Well, you can imagine how broad a definition that is, and you can imagine how broadly that would apply, especially in a COVID environment. So suddenly, this Warren Act provision that historically was only available in federal level is now suddenly going to be popping into Maryland as of July 1, and I think that's going to be a really big deal. One final point on this slide is that starting on July 1 in Maryland, you're not allowed to ask for background with respect to wage history. Wage history inquiries are now going to be illegal in Maryland, and nor can there be any retaliation on that. So the bottom line is, not only do we have a lot of major HR and employment related changes on the federal level, but you should be aware of them on the state level as well. If we can go to the next slide, which is my last slide, I wanted to just kind of tie this all together in the end as to what are the best practices for returning to the workplace. You know, we know that we're about to turn, I call it turning the lights back up instead of turning the lights back on. We're working, but we're working largely remotely. So how do you turn the lights all the way back up and bring people back? That's going to be a major process. The best way to do that, as we're recommending to our clients, is to have a written return to work policy that provides advanced coordination and notice as to the way that you're going to be onboarding people, the way that you're going to be sanitizing the office, the way that you're going to be able to perhaps have people rotating in shifts. Develop the policy, notify of the policy, share it, make sure it's very transparent. Set up a pre-coordination meeting with your lead staff so that they're completely on board from a messaging standpoint. I think that you should also have a separate telework policy. It can be a part of your return to work policy, but it needs to be separate and distinct, because we're not going to all turn the lights on immediately overnight. And there needs to be some guidelines that are set as well. In addition to making sure that you have disinfection, PPE, and everything ready to make sure that you have return to work, make sure that you're ready to provide reasonable accommodations to the extent that people are immune compromised. And be very sensitive to that from an HR and a communication standpoint, because to the extent that these are things that arise, you want to make sure that you maintain regular coordination and collaboration with your staff. We wish everybody luck as they continue to turn the lights back up. And in the interest of saving time and remaining questions, I'll turn it back to Gary.
Thanks, Seth. That was great. I really appreciate that. Just to add on to what Seth was saying, we've been looking at a lot of information. You'll see the Chamber of Commerce information I mentioned earlier, talked about some helpful hints and guidelines. Maryland State Bar has actually given us some information on putting guidelines together and manuals together for reopening, or as Seth said, turning the lights back up. And I know his firm is doing a great job in helping clients with just going through the process of figuring out how to turn the lights back up and best plan for doing that. So I really appreciate that, Seth. Thank you so much for all the information that you gave us today. I know we're at the hour, but I just want to see if John Silverman has some questions. And if he does, anyone who wants to stay on, we would appreciate that. So John, let us know what you have.
Yeah, absolutely. I actually have 3 questions as of now. And if anybody has anything additional, please just write it in the chat and we will get to it. For the first question, it's going to go over to Chris Staub. The question is, can you explain when health insurance claims would become a workers' compensation claim?
Sorry, I was muted. That's a great question, and there's a bullet on one of those slides that I didn't go into in extreme detail, but it's always an interesting question where health insurance starts and where comp starts.
Oh, you can just toss it right there. Thank you. Appreciate it.
And I think that health insurance is always usually meant for injuries, illnesses that happen outside of the workplace. And the real, I guess, line there is if the employee can prove that there's a direct causal connection to the workplace. In other words, did they get COVID? Did they get coronavirus from some workplace environment? Then that could go into a workman's comp claim rather than a health insurance claim. So that's a big differentiator there. And on the job, off the job, that's why when you go into the emergency room for a broken hand, they always ask you, did this happen at work? Because if you say yes, then that's going to be a workman's comp claim.
All right, perfect. Thank you so much. And I actually have another question for you, Chris. In these pre-funded benefit plans, how liquid are these assets?
Great question, because there are kind of 2 ways to do this typically. There's a lot of firms out there that do pre-funded benefit accounts in insurance type arrangements where they usually are not a very liquid asset. Usually it's a long-term type of a play. We don't typically do that for our clients. We are typically using mark-to-market investments inside of securities portfolios. So they are very liquid. We can get assets to our clients in a day or 2. Trade plus 2 days is usually the industry average. So very liquid. We do usually want clients to have a longer term approach with these type of benefits or type of investments. But our typical arrangement is very liquid. Although some insurance arrangements could be more on the illiquid as well.
Perfect. Well, thank you so much, Chris. Final question is for Seth Barensweig. The question is, in order to receive the additional 2 weeks of paid sick leave under the FMLA for COVID-related reasons, is the employer permitted to require proof from the employee seeking this leave?
Thank you. That's a great question. The short answer is yes. You are able, as the employer, to require documented proof with regard to leave, such as medical leave, because ultimately you'll need those materials in the employment file for record and audit purposes. However, one of the things that I would also recommend as a part of that is to provide a degree of flexibility from a timing perspective as to when the employee will be able to provide that, because from a practical standpoint, It may take a while to be able to get a doctor's note. Some doctor's offices have been closed. They might not physically, literally be able to go in and do that. But generally, yes, provided that you let them know that they can have a reasonable time frame from an accommodation standpoint. Get documentation with regard to medical leave. Maintain documentation in the HR file with regard to other kinds of leave. If there are executive orders and closures that are triggering extended family medical leave or family coverage, have that as well. And then that way, when you get reviewed later from a financial and accounting standpoint, you could have those secured for purposes of your company's records.
All right. Great answer. Thank you so much. And before I turn it over for the closing remarks from Gary, I just want to mention that if you have any additional questions, please keep commenting them into the YouTube link. We'll be reviewing them and answering them as they come in. So thank you.
Thanks, John. Thanks for those questions. Well, that's the time we have for today. Thank you so much for joining us. We will certainly be planning additional events as the need arises. And more importantly, we really appreciate the folks who joined us in the beginning and stuck around to the end, and really appreciate all of those questions. As I mentioned earlier in the event, we're going to be making a donation to the Children's Miracle Network of Hospitals. So good work to you for joining us. Good work to everyone for participating. It really is much appreciated. As John said, if you have any additional questions, we'll keep taking them. We hope you found this helpful. We hope that we were able to answer all of your questions. In the event, again, there are any questions that you don't want to chat, feel free to reach out to any one of us. Our website information, our email information is on the back page of this event. Again, you can find the event on our YouTube channel, LinkedIn page, and our website. If you have any information that you want to ask questions about that we didn't cover today, please ask those questions as well. Again, thank you all. Be well, be safe, and thanks.